So let's travel back. We're talking 1977 India. The nation's just sort of cautiously stepping out from, well, what our sources call the dark shadows of the emergency.
Right, and you really can't overstate the mood then. It was electric, definitely, but also deeply skeptical. This period, the emergency, it wasn't just politics, it was a genuine national trauma.
Yeah, civil liberties suspended, censorship everywhere, this pervasive fear. It really touched everything.
Absolutely. And coming out of that, with the memory of executive power running wild still so raw, people were forced to ask some really basic questions again. Questions about freedom, about government power.
And that's where our deep dive begins today, with a conflict that, on the face of it, seems quite small. One woman, her passport taken away.
But it became the spark, didn't it? The catalyst for this huge legal shift, something with truly global consequences.
That woman was Maneka Gandhi. And her challenge, this very specific legal fight about her travel documents being impounded, crucially, without any reason given.
Yeah.
That became the crack that broke open Indian constitutional law.
It really did. It's an amazing story of how fighting over essentially a piece of paper ended up redefining liberty for, well, over 1 billion people today.
So our mission here is to give you a shortcut, really, to understanding this absolute landmark case from 1978, Maneka Gandhi versus the Union of India.
We're going to trace how this single ruling just fundamentally rewrote the rules on freedom and procedure in India. And the critical part, the real bombshell, was how it effectively brought in the idea of due process.
A principle that, maybe surprisingly, the courts had actively pushed back against for almost 30 years before this.
Exactly. Rejected it quite forcefully, in fact.
Our sources, mainly sharp legal analyses, they're going to guide us through this judicial transformation.
Yeah.
Now, why should you, listening now, care about a court case from way back in 1978?
Oh, because understanding Maneka Gandhi is fundamental if you want to grasp how constitutional rights actually work in the real world. They aren't static things locked away in a vault.
Right, they evolve, they expand, especially when governments get tempted to act arbitrarily, which, let's be honest, happens.
It does. And this case is the story of how the meaning of words in the Constitution shifted, how liberty went from being something the government allowed, like a permission slip, to being understood as an inherent right you're born with.
It's like the Constitution found its voice.
That's a great way to put it. It stopped being just a shield for the state and became this active, dynamic guardian of the individual. A living document.
Okay, so let's dive into that 1977 context. The emergency is over, Indira Gandhi's government is out, the Janata government is in power. Talk about a political whiplash.
Oh, absolutely. The pendulum had swung hard. And the whole country was, you could say, almost allergic to anything that even smelled like government overreach.
Because the trauma was so recent. The memory of rights just vanishing overnight, political opponents jailed, newspapers shut down, the government basically saying we could do whatever we want for national security. That was fresh.
It was raw. People were demanding accountability. They were watching the new government like hawks, scrutinizing every single move.
And then there's the person at the center of it all, Maneka Gandhi. Her profile adds another layer entirely, doesn't it?
It really does. She wasn't just anybody. She was young, a journalist, known for being outspoken, and crucially, she was the daughter-in-law of Indira Gandhi.
The very leader who presided over the emergency.
Exactly. So this immediately took her personal legal fight and put it on a national stage. It wasn't just citizen X versus the state. It was politically loaded right in the shadow of this recent authoritarian period.
It turned what could have been a dry administrative issue, getting her passport, back into this huge public debate about the limits of state power, about fairness.
Yeah. So the specific action, the government orders her passport impounded. They used Section 10(3)(c) of the Passport Act of 1967.
And a passport that's key to the right to travel abroad. Taking it away is a serious restriction of liberty.
A very significant use of state power. And the government's justification, they just said it was in the interest of the general public. Vague.
But here's the crux, the point our sources really hammer home. The critical mistake, the procedural failure that blew the whole thing open. They impounded it without giving her any reason, no explanation, no prior warning.
Nothing. Just hand it over. We don't have to tell you why. That was basically the message.
And that smacked of the exact kind of arbitrary power people had just lived through during the emergency. It was a direct challenge.
And she didn't just accept it. She fought back using the most direct route available under the Constitution for protecting fundamental rights. Article 32.
Article 32. Let's pause on that for a second because it's so important. Often called the heart and soul of the Constitution. Why?
Because Article 32 guarantees the right to go to the Supreme Court directly if you believe your fundamental rights have been violated. It's the right to a constitutional remedy itself.
So she didn't have to start in some lower court, wading through bureaucracy for years.
Nope. Straight to the top. She could demand that the highest court in the land address this violation immediately. That's what makes Article 32 so powerful. She turned a seemingly bureaucratic order into a major constitutional showdown over arbitrary procedure.
So the question she put before the Supreme Court was simple, but incredibly profound. Can the government just take away my rights, restrict my movement, without a fair process, without even telling me why?
And that question forced the court to grapple with a really fundamental tension. The difference between, let's say, formal liberty and real substantive liberty. And this meant revisiting a ghost from the past.
The ghost of Gopalan. You're talking about the 1950 case, A.K. Gopalan versus State of Madras.
That's the one. For nearly 3 decades, Gopalan had set the rules for how Article 21 was interpreted. And it was a very narrow interpretation.
Okay, remind us. Article 21 says, no person shall be deprived of his life or personal liberty except according to procedure established by law. What did Gopalan say that meant?
Gopalan read, procedure established by law in the most literal, formal way possible. It meant any procedure written down in a law passed by Parliament. That's it.
So as long as the government followed the steps listed in the statute, even if the statute itself was incredibly unfair or harsh.
The court said, our hands are tied. The judiciary, according to Gopalan, had no power to ask if the law itself or the procedure it laid down was just, fair, or reasonable, only whether the government checked the boxes in the law.
Wow. So if Parliament passed a law saying confiscate passports arbitrarily, no reasons needed, and the government did exactly that under Gopalan, that was perfectly constitutional.
Precisely. It protected you from the government not following the law, but not from the law itself being oppressive. It was procedural formality over substantive fairness.
And Gopalan specifically rejected the American idea of due process, right? The idea that the law itself has to be fair.
Explicitly rejected it. The judges back in 1950 were worried. They thought adopting due process would give unelected judges too much power to strike down laws made by the elected parliament. They feared judicial overreach, interfering with democracy.
So for 28 years, Article 21 was a pretty weak shield. It protected against arbitrary actions outside the law, but not against arbitrary laws.
Correct. The state just needed a law, any law, and had to follow its steps. That's why Maneka Gandhi was such a high-stakes moment, especially after the emergency.
The court had a choice. Stick with the restrictive Gopalan view, which kind of validated the emergency-era mindset, or make a radical break and redefine liberty.
Were they finally ready to say that procedure wasn't just about following steps, but about fairness? That was the question. The fate of constitutional liberty really hung in the balance.
And in 1978, they answered. A 7-judge bench, led by Justice P.N. Bhagwati, delivered a verdict that, as our sources say, genuinely revolutionized Indian constitutional law.
It absolutely did. And the core of that revolution was a completely new way of reading that key phrase in Article 21, procedure established by law.
What was the shift? What was the ratio decidendi, the core legal principle?
Justice Bhagwati in the bench said, look, procedure established by law cannot just mean any old procedure Parliament cooks up. It can't be arbitrary, it can't be fanciful, it can't be oppressive.
So what's it be?
It must be a procedure that is just fair and reasonable. That was the magic formula.
Just fair and reasonable. Injecting those 3 words changes everything, doesn't it? It completely overturns the logic of Gopalan.
Completely. Because now the court wasn't just checking if the government followed the law. It was checking if the law itself and the procedure within it met a standard of basic fairness and reason.
So this is basically due process coming in through the back door.
Effectively, yes. They didn't explicitly adopt the American term, maybe because of the historical baggage from Gopalan. But by insisting the procedure must be just, fair, and reasonable, they achieved the same result. The substance of the law now mattered.
But hang on, let me push back here, like the Gopalan court might have. If judges are now deciding what's just, fair, and reasonable about a law Parliament passed, aren't we back to that problem of judicial overreach? Unelected judges overruling elected representatives? Isn't that messing with the separation of powers?
That's the crucial counter-argument, and the court knew it had to address it. Their solution was ingenious. They didn't just pluck just, fair, and reasonable from thin air. They anchored it firmly in other parts of the Constitution itself.
Ah, this is where the golden triangle comes in.
Exactly. The golden triangle of rights, Articles 14, 19, and 21. The court said these three fundamental rights don't live in separate boxes. They overlap, they intertwine, they work together.
Okay, so how does linking them solve the judicial overreach problem?
Before Maneka Gandhi, you could test a government action against Article 21 liberty, and it might pass even if it seemed to violate Article 14 equality or Article 19 freedoms. The court said no more. Any law or action that restricts life or liberty under Article 21 must also pass the tests of Articles 14 and 19 simultaneously.
So if it fails on either 14 or 19, it automatically fails on 21.
That's the breakthrough. It creates an interconnected test. Let's break it down.
Okay. First, Article 14, equality before the law and equal protection of the laws. How does that connect?
The court made a vital link. Arbitrariness is the enemy of equality. If the government acts arbitrarily, like taking Maneka Gandhi's passport without giving any reason, that action is inherently unequal and unreasonable. It fails the non-arbitrariness test implicit in Article 14.
Because the articles are linked.
If the action fails Article 14 because it's arbitrary, then the procedure used under Article 21 cannot be considered just, fair, and reasonable. The arbitrariness poisons the procedure.
Got it. So they use the existing guarantee of equality in Article 14 to define what reasonable means for Article 21. Clever.
Very. Arbitrariness became the constitutional acid test.
Okay, second corner of the triangle, Article 19. This protects specific freedoms, speech, assembly, movement, etc. How does that fit in?
Article 19 brings in the idea of proportionality. The court recognized that the right to travel abroad wasn't explicitly listed in Article 19, but it was fundamentally linked to the freedom of movement and speech. So any restriction on liberty under Article 21 that also impacts an Article 19 freedom, like travel impacting movement, must be reasonable.
And Article 19 already had built-in tests for reasonable restrictions on freedoms, right?
Exactly. So the restriction couldn't be excessive. It had to be proportionate to the goal it was trying to achieve. If impounding the passport was an unreasonable or disproportionate restriction on her freedom of movement or expression, it would fail Article 19.
And therefore fail Article 21 as well.
Correct. The procedure wouldn't be just, fair, and reasonable if it imposed an unreasonable burden on other fundamental freedoms.
In the third corner, Article 21 itself becomes the ultimate check, now infused with the requirements of non-arbitrariness from Article 14 and reasonableness proportionality from Article 19.
It creates this interlocking web. The court isn't imposing its own values, it's enforcing the Constitution's own internal logic that true liberty requires equality and respect for fundamental freedoms. If a procedure is arbitrary, violates 14, or imposes unreasonable restrictions, violates 19, it simply cannot be considered a procedure established by law under the newly interpreted Article 21.
It's like a three-legged stool. Take one way, fairness, equality, or reasonable freedom, and the whole thing collapses.
That's a perfect analogy, and this whole philosophy was captured powerfully by Justice Pagwadi in a quote our sources highlight. The spirit of the Constitution must be interpreted broadly to ensure that liberty expands, not contracts.
That's a mission statement right there. It tells the courts and the government that the default setting should always be towards more freedom, not less.
It fundamentally repositioned the judiciary, not just as a referee calling fouls, but as an active guardian ensuring the spirit of liberty, embedded throughout the Constitution, was protected and indeed expanded over time.
Okay, so we've got the theory. The golden triangle, just, fair, and reasonable substantive due process arrives in India. Let's talk about the impact. What changed on the ground?
The immediate impact was a massive check on arbitrary government power. Think about preventative detention laws, for example. Before Maneka, the government just had to follow the steps in the law, detain someone, maybe give some vague grounds later.
But after Maneka,
The government had to show that the reasons for detention were reasonable, that the detention itself was fair and not arbitrary, and that the process provided to the detainee was just. The entire basis for detention could now be challenged on grounds of fairness.
so the judiciary suddenly had this powerful tool to strike down government actions, even actions based on existing laws, if they failed this new combined test of fairness, equality, and reasonableness from the Golden Triangle.
Absolutely. It shifted the balance of power significantly towards the individual and judicial oversight. The state couldn't just hide behind the letter of the law anymore. The spirit of fairness mattered.
But you mentioned earlier that the really huge societal shift was something else this enabled. Public interest litigation, or PIL. How did Maneka Gandhi lead to that?
It's all about that expanded meaning of Article 21. The court didn't just stop at procedural fairness. It said life and personal liberty means more than just not being killed or locked up. It means the right to live with basic human dignity.
Life with dignity. That sounds broad. What did it come to include?
That phrase became the launchpad. Once life included dignity, the court started finding that dignity required certain other basic rights, things that weren't explicitly listed as fundamental rights before, often social and economic rights.
Like what? Give us some examples.
Well, things like the right to a speedy trial because indefinite waiting violates dignity, the right to free legal aid for the poor because you can't have fair procedure without access to justice, the right to education, even critically, the right to a clean environment.
Wait, the right to a clean environment came out of Article 21.
The logic, flowing directly from Maneka Gandhi's expansive view, was that you can't live a life with dignity if your environment is so polluted it threatens your health and survival. So citizens could now go to court, citing Article 21, to fight against pollution or environmental destruction.
That's incredible. Before Maneka, you couldn't really argue that a polluting factory violated your fundamental right to life, could you?
Not effectively, no. Maneka Gandhi provided the constitutional hook. It allowed the courts to read these essential social and economic needs into the guarantee of a dignified life.
And this led to PIL because
Because it massively expanded the scope of fundamental rights that could be brought directly to the Supreme Court under Article 32. And crucially, the courts also relaxed the rules about who could bring a case.
You mean you didn't have to be the person directly harmed anymore?
Exactly. Public-spirited citizens, journalists, social action groups could now file petitions on behalf of marginalized groups or for issues affecting the public good, like prisoners' rights, bonded labor, environmental protection. They didn't need personal standing, just a legitimate public interest.
So it really democratized access to the highest court. It wasn't just for the Maneka Gandhis of the world anymore.
Precisely. It turned the Supreme Court into a forum where the concerns of the poorest and most vulnerable could be heard, where systemic issues could be tackled. PIL, flowing from Maneka Gandhi, fundamentally changed the role of the judiciary in India, making it a powerful engine for social change.
And this powerful idea, this robust protection of liberty through fairness, didn't just stay within India's borders, did it? Our sources mention its influence spread.
Yes, and that's always a sign of a truly landmark legal development. Ideas about fundamental rights, especially effective ways to protect them against state power, tend to travel across jurisdictions.
Particularly in South Asia, where countries often face similar challenges with balancing security and liberty.
Exactly. When constitutional courts in neighboring countries like Pakistan were dealing with their own cases involving executive overreach or fair trial rights, they looked at what the Indian Supreme Court had done in Maneka Gandhi.
So how specifically did it influence Pakistan's law? Which articles were involved?
The principles from Maneka Gandhi especially, the idea that government action must be non-arbitrary and reasonable, resonated in the interpretation of Pakistan's own constitutional guarantees. We see echoes in how their courts approached Article 4, on the right of individuals to be dealt with according to law, Article 9, security of persons, similar to India's Article 21, and particularly Article 10A.
Article 10A in Pakistan is the right to a fair trial and due process, isn't it? That sounds very relevant.
It is. It was added later, but the jurisprudence around it and around Articles 4 and 9 increasingly reflected this Maneka Gandhi-inspired insistence that legality isn't enough. The state's actions must meet a substantive standard of fairness and proportionality.
So the Indian court's reasoning provided a sort of blueprint, or at least strong persuasive authority, for judges elsewhere grappling with how to make constitutional rights meaningful in practice.
Absolutely. It showed a way to ensure that procedure established by law didn't become a shield for tyranny, but instead incorporated basic norms of justice. That ripple effect really underscores the global significance of the Maneka Gandhi ruling.
Okay, so let's try and wrap this up. We started in that tense post-emergency moment in 1977. We followed Maneka Gandhi's fight over her passport, and we saw how it led to this incredible judicial transformation.
A shift from just checking boxes procedural formality to demanding real fairness, substantive justice, all anchored in that powerful idea of the Golden Triangle, Articles 14, 19, and 21 working together.
And the core lesson, the moral of this story that our source material really emphasizes.
It's simple but profound. Freedom isn't something the government gives you, it's your birthright. And the Constitution, as interpreted by cases like Maneka Gandhi, is there to guard it.
The government doesn't get to just arbitrarily decide who has rights and who doesn't. It has to justify its actions, always, against this standard of being just, fair, and reasonable.
That case gave the Constitution real teeth. It ensured that the spirit of liberty, that idea of expanding freedom, would guide interpretation, not the restrictive letter of potentially unfair laws.
It's a testament, really, to how one individual challenging one specific act of unfairness can trigger changes that protect everyone.
Absolutely. But here's a final thought to leave you with, something that builds on all this. We've seen how Maneka Gandhi empowered the judiciary by making just, fair, and reasonable the standard.
Right, that's the core of substantive due process now in India.
But think about it.
Yeah.
Who gets to decide what is just, fair, and reasonable in any given situation? The definition isn't fixed. It evolves with society, with technology, with new challenges. That power rests largely with the judiciary.
So the question then becomes,
How much power does this give the judiciary, an unelected body, to essentially define the boundaries of democratic action? And if the courts hold that much power in interpreting fairness, what responsibility does that place on us, on you, the listener, to actually understand how those lines are being drawn and to engage with whether those interpretations truly uphold the spirit of liberty that Maneka Gandhi fought for, that constant vigilance, that understanding? Maybe that's the ongoing price of the freedom secured back in 1978.